little bit early today. It's like 0600. It's a beautiful day today in Summerlin, Nevada. And I haven't gone live. I used to do lawyer workouts in the morning, but I get somewhat back in shape the last couple of weeks, taking gabapentin and a bunch of other crap. So, I apologize that I haven't been going live like I used to as much. Taking a little bit different route today. I'm going for a walk. I'm in a lot of pain, but my doctor said that the best thing to do is to try to walk as much as possible when you're hurting like this. And so that's what I'm doing. And so today I'm going to talk about civil writs and criminal writs. And I am a lawyer licensed in California and Texas. And that's what I do I got my start in appellate law and criminal defense, and ultimately ended up clerking for several personal injury attorneys and became very good at tort law and personal injury law. And so now for about 20 years, I've become an expert in PI, and then I've done other stuff on the side like Habeas Corpus, getting people out of jail. Became an expert in appellate work initially, became a lawyer with no law degree or undergrad, and even got an opportunity and in fact took up the opportunity to extern for the California Court of Appeal. So I'm one of the first, probably the only guy I know on a law study program who externed for the Court of Appeal. I have a lot of experience, and I've been getting a lot of emails and text messages from people about Lane Myers and can I help? Can I join in and help as part of his defense team, et cetera, et cetera. And my main issue is that as soon as I sit down in an airplane, my whole left leg lights on fire like razor blades. But I'm still gonna make a good faith effort to try and become, if Lane will accept me, to become part of his team, because even from afar, I could help with I could help with writs, appeals, interlocutory appeals, and things like that, so long as I'm up to snuff on Arizona law. And as you guys probably noticed, I did a video earlier about direct douche and MERB, how they're having this battle about writs and appeals in Arizona. And obviously, Direct D completely cleaned the floor with MERB, and I thought that was pretty impressive, to be honest. I mean, I think I don't really like either one of them. I think they're both creeps, and it's unfortunate because we should all be part of the same team, because the enemy is at the gates, and what the enemy wants is for us to tear each other apart instead of trying to help and love one another so we can protect our families and our kinfolk from the banksters and the people who created fiat currency and basically destroyed our way of life and stripped us of everything that was valuable as being an American. Give me a bunch of ones if you agree. Oh my gosh, check it out. What's going on? What's the matter, you? And Salt Shaker, that's OTVO, good seeing you. Cops are 5150, good seeing you. Awesome. So this morning I'm going to talk a little bit about civil writs, and I'm going to talk about criminal writs, because that is the issue that seems to be sort of afloat in our community of patriots and people who believe in natural law. And so the first one we're going to talk about is the civil writs. And I brought some notes with me, so I'm kind of like looking down at my notes as I'm walking. Hopefully I won't walk into a power pole or something. But it's good seeing you guys. I'm super happy to be here. I've had a really rough go of it with this, and so when I say I blew out my back, what a lot of people don't get is with sciatica, it's not your back that hurts. What happens is, you're like in my case, my L5, and this is from when I was in the Marine Corps, I walked with an irregular gait because of my knee injury. I'm a 70% disabled vet. I refuse to go back to get re-rated because I'm afraid they're going to find me 100% unemployable. And then I'll just be stuck with making like I don't know, $5 grand a month, and not be able to have a job. So it really is shitty, to be honest, the way the system works. But so because of that, over time, the L5 impinges, and I have a huge disc bulge. And so the L5 impinges on that sciatic nerve, and then that sciatic nerve that runs down the left side all the way down to your big toe pretty much, it hurts really bad, and to the point where I can't do judo anymore. I can't do my satisfying throws. It just sucks. So that's kind of where I'm at. So all you guys who are upset at me for not like immediately rushing to Arizona and helping Lane, it's not that easy, guys. I mean, as it is, I work off my back on my laptop, and I'm doing telephonic and Zoom appearances. So imagine trying to do a deposition while you're in bed. It's not easy. But that's kind of what I've been doing for the last, I don't know, almost 2 months. And devastated my YouTube channel. I was up over 1 million views a month. Now I've gotten it up a little bit. I was down to 90,000 before I started going on YouTube again, but now I think I'm up to about 300,000 views a month. But with your help, we'll get it back. But just don't be upset at me for not like jumping on an airplane and flying to Arizona to help Lane, because I went to Texas to support my brothers at the Leathernecks Motorcycle Club, and I was just hopped up on pain meds just to make it on the plane. And when I got back, man, I was in bed for about a week solid. It hurt so bad, and I've gained a lot of body fat because I haven't monitored my food intake, but I'm trying my best, okay, guys? Just so you guys know, I'm doing everything that I can to try to do these shows and teach my kids how to be entrepreneurs and all that good stuff. So first thing we're going to talk about is civil writs, all right? And I'm going to talk about them from the basis of California, because that's where I got my start. And if you guys saw Direct D and you saw what he did on his show, where he schooled that low-life scumbag Merb, he talked about how Arizona has a different classification, a different way that they entitle their writs. And so I'm not an expert on Arizona writs, but you know, I could be in probably 2 hours if I took the time just to sit down, and I will. I've already purchased a copy of Arizona Practice and Procedure on Writs, so I shouldn't end appeals, so I should be able to get up to snuff on it. And of course, what you guys need to know about me is, with respect to Lane's case, you know, I'll do what I can to help his significant other and his family, because I look at it more like he's being deprived of his family. And then just to give you a little rundown, so he was promised by the judge that he would have access to the law library, and that was on the record. And of course, if the judge knew that there was no law library, and there hasn't been one for 2 years, then that could potentially be a case where the judge could be removed from the case or even removed from office, because it was, in my opinion, a disingenuous order, or wrongly decided, if that's true. So that would be a case where we would try to file a writ or perhaps an interlocutory appeal. Again, because it's Arizona, I've got a little bit different of a take on it. So I've got to do more research. But what I'm going to do is I'm going to give you the general legal principles as I would approach this from a California perspective. Hey, Stomper, good seeing you. So I got a couple of my buddies in here this morning, which I appreciate. So let's talk a little bit about civil writs first. Now, Lane's case is a criminal case, and I guess he's been charged with like 21 or more felonies, and they keep on stacking more felonies on him. And you guys already know my position on their harassment law. I think there's some as-applied issues with that statute, as well as some vague and ambiguous problems with that statute that make it unenforceable and make it at the very least unconstitutional. And I've talked about that in other videos. But in this video, first we'll get into civil writ so you'll understand the difference between civil and criminal writs. So the first thing you want to do is, we'll talk about a writ of mandamus, or in California, I think we call it a writ of mandate. And in California, that would be under California Code of Civil Procedure, Section 1085. And typically, I would file a writ of mandate in a civil case when I have an issue where a public official, agency, or lower court has failed to perform a mandatory duty that they're supposed to perform. And so let's say I'm in a trial court, or I'm dealing with a DMV, or some agency that's trying to euthanize my dog. I would immediately try and, well, maybe get a writ of supersedeas first to stay anything, but I would go up on a writ of mandate to mandate that the court first follow a procedure before doing that. So there's a distinction between a writ of mandate and a writ of prohibition, where you're straight trying to get the court prohibited from doing something. Are you guys following me so far? Hopefully you guys are. So an example would be ordering a government agency to issue a permit that was wrongfully denied. All right, so let's say I wanted to protest the Marxist Democrats, and I was in San Francisco, and of course we know that they love to silence anything that has to do with the First Amendment unless it supports their Marxist communist agenda. So the permit would automatically be denied. So I would have to seek a writ of mandate or a writ of mandamus to be able to get that permit. But now the test is going to be, the duty has to be clear, it has to be ministerial, non-discretionary, and the petitioner must have no other adequate remedy. And obviously, in a case where you're denied a permit, well, what other remedy do you have but to violate the permit law? Now, many of you will say, well, the First Amendment gives you the right of speech and you should just be able to go and protest wherever you want. Hold on. But that's not how it works. That's what those people are doing right now when they block the freeway and they push their climate change narrative so they can raise our taxes and make it impossible for us to get gas in our cars, right? The same people who key Teslas and claim that they want green energy, those guys. So basically, hold on a minute. I'm trying to pay attention when I'm walking here. Oh. All right, here we go. So I'm going to go to the park here to try to avoid these dogs because I don't want to end up getting charged when I pop one of them with a 380 auto, because these dog owners they do not properly walk their dogs. They'll let their dogs come up and bite you or sniff you, and the dog may try to bite you. So I'll try to stay away from them. All right. So let me see here. Tesla is bad now. It's hard to make sense of it. Well, Tesla is bad because the Marxist Democrats don't like it that they're being exposed for stealing billions of dollars from the taxpayers through U.S. aid, funneling it to their buddy companies, their friendly companies. And then those companies, once these people are out of office, will hire them as consultants at millions of dollars a year, so they'll get some of that money back. It's a total racket. Give me a bunch of ones if you agree that none of our tax dollars should be sent to any non-governmental organization. Non-governmental organizations were subsidized with your tax dollars to flood our country with over 20 million illegal aliens so they could turn the entire country blue. And many of you will say, well, illegals aren't allowed to vote. That's misinformation. Well, that's BS. First of all, it's not about them being able to vote. It's about using the United States Census to turn everything blue. That's what it was really about. That's how they turned California blue. You flood the whole country with illegal aliens, you send them to blue districts, and the districts split. and they get new congressmen and new senators, so they don't even need to have an election. They can literally steal an election with illegal aliens. That's what they did in California. And so what ends up happening is, as a result of this, they don't have to vote, but they do vote. In California, they register illegal aliens to vote at the DMV. That's how you get your license. You're automatically registered to vote. We know that they were actually trying to register illegal aliens to vote in Pennsylvania. There's actual photographic and videographic evidence of that, where they literally had voter registration stations right outside the DMVs and stuff in Pennsylvania. And that was all caught by the guy from Project Veritas. And of course, Communist News Network and PMS NBC always try to say you're a conspiracy theorist if you mention any of that. But anyways, let's go back into different types of writs. So, by the way, that would be a good example for a writ of mandate, mandating that the DMV not register people to vote in violation of voter laws. But the problem is, in California, there's no voter ID. And once you get registered to vote, which is what they do at the DMV, illegal alien or not, these people are on the fast track to getting registered. And the leftist courts in California refuse to look into that. So good luck. And good luck with the Ninth Circuit. Ninth Circuit is very far left, the most overturned circuit in the nation, because they don't really apparently follow the Constitution. They follow what many people call our Marxist principles that go against everything our founding fathers stood for. Give me a bunch of ones if you agree with that, or give me a bunch of twos if you think I'm some kind of crazy conspiracy theorist. I'm okay with that. Okay, now writ of prohibition. Illegal registration at the DMV. Another example. One could try and file a writ of prohibition civilly against the DMV for registering illegal aliens to vote, which we know they do. They absolutely do that in California. 1,000,000% true. And you could try to seek a writ of prohibition. You could argue that the DMV doesn't have the authority to do that. Now, typically, a writ of prohibition, however, would have to deal with prohibiting a lower court or a tribunal, this is civilly, a lower court from acting beyond its jurisdiction or authority by upholding something like that, like allowing illegal aliens to be able to continue to be registered to vote. So, halting a court proceeding where the court lacks jurisdiction over a case would be another way that we would deal with a civil writ of prohibition. But you have to show that the lower court is acting outside of its legal power. And that is, it's a difficult burden to prove. And typically, writs are not the favored methodology in a civil proceeding. Typically, a judgment on the merits followed up by a writ of certiorari or something like that would be the favored methodology. So basically, a writ of prohibition, again, hold on a minute. Give me a second, guys. Trying to read and walk's not the easiest thing. Basically is going to be limited in most cases to where a lower court has acted outside its jurisdiction and it's provable. And again, it's so political now. The courts have become political tools of, unfortunately, the left. From what I've seen throughout my practice is that the conservative courts really try and stay within the confines of the U.S. Constitution, whereas the leftist courts and the Obama-style judges try and find a way to go outside the Constitution, especially with the Second Amendment. They'll do anything they can to try and take away your firearms and come up with some crazy excuse. And it reminds me a lot of how the British justice system is. And we know that the left is trying to form a globalist one world government, and there's no place for a U.S. Constitution in that situation. Now, let's get on to the next one. Now, This is CCP 1067, writ of certiorari. Now, the writ of certiorari is going to review a lower court or agency's decision to determine if it acted without jurisdiction or violated due process. So a lot of people think of writs of certiorari strictly in a criminal sense, but no, a writ of certiorari is going to also have validity in a civil case, because deprivation of property or rights don't always implicate criminal statutes or criminal enforcement. So typically it would be challenging a quasi-judicial agency decision like a licensing board ruling for procedural errors. We've seen the ATF doing that, constantly trying to take away federal firearms permits. Under Obama and Biden, it reached record levels because we know that their party is the party of stripping people of their Second Amendment rights. And so the ATF has been used as a tool to try and strip people from the ability to obtain a firearm. And an FFL is a federal firearms license. And starting with Obama, he outsourced all of our lead production from the United States. So you can't even manufacture bullets anymore in the US. A lot of people don't know that, or at least it's a lot harder because now you have to import the lead. So Obama, probably the greatest traitor to this nation, is responsible for that. And he packed our agencies with far, far left Marxists. These are the same people who spread the false Russia narrative, like Peter Strzok and Lisa Page, the insurance policy, all that. Hopefully we'll be able to weed them out now. But in any event, the key test for a writ of certiorari is it's limited to jurisdictional errors and serious procedural defects, not for reviewing factual disputes. Next, civil again. Writ of habeas corpus. A lot of people don't know that, yes, a writ of habeas corpus definitely can lie in a civil case. So basically, rough translation from Latin is produce the body, right? When someone's body has been locked up or put away, like let's say in a nursing home. Let's say you've had you've been put into a mental institution by some judge who thinks you're crazy because you post pro-Second Amendment videos, which could very likely happen in a place like California, right? So you would see, and it's not criminal, it'd be civil. So they'll send Child Protective Services to steal your kids from you if you refuse to recognize the so-called gender that your public school teacher has assigned to your child. And so they'll strip you of your child, place your child with a nice gay family or a nice non-binary family, foster home, and then commit you civilly. And this actually does happen in communist California and states like Colorado. So you would have to seek a writ of habeas corpus. And the purpose is to challenge unlawful detention or restraint of liberty in non-criminal settings. For example, civil commitment or child custody. And in California, that is CCP, California Code of Civil Procedure, Section 1473, et sec. So when I say et sequitur, all that really means is the primary section that we're looking at is that code, but et sec means in other places as well. Give me a bunch of ones if you understand what that means, because a lot of you guys who aren't lawyers, I just assume that you know these things, but I shouldn't. So et sec just means that in other places, so there might be a case that interprets that statute. And I know, like guys like Wassa, I know you don't believe in case law, but case law has been used for hundreds of years in common law to interpret statutes and interpret common law, which just means law of the common man, in order to eliminate any confusion. Because if we didn't have a stare decisis or some way to a seminal case that interprets it, then you would have no way to know how to have uniformity in the enforcement of law or understanding of law. However, I also agree with what's the matter you that it gets out of hand. And it basically becomes a political battle. And I don't know what the answer is, brother. I really don't. But I'm just telling you that et sec simply means as interpreted by other cases or found in other cases besides just the statute. So that's all that means. All right, hopefully you guys are learning, because my goal here is to teach you about stuff. Let me see here. California, that's right. You guys are amazing. Good seeing all you guys this morning, by the way. This is the first time I've been able to go for a walk like this in a long time. And I've been taking gabapentin and unfortunately oxy, which, as you guys know, that means it may take 3 or 4 days before I can actually, do my normal morning business, which really sucks because the stuff just clogs up your intestines big time. I guess it shuts off the nerve signals that would promote you having a regular movement. So without sounding too gross, ladies, don't take it if you can avoid it. But yeah, speak life. Well, I try to do that, speak life, and I do the inversion table, and then I do walking, and I try to do homeopathics. So I do as much as I can to engage in homeopathy and stay off of the government prescriptions and all that other crap, which just leads to a side effect, and we don't want that, right? We don't want side effects. All right, so let's keep on going. So if you guys have any questions on civil writs of habeas corpus, speak now or forever hold your peace. As you can see, I'm at a little football field here, trying to stay away from people. Man, what a beautiful morning. Look at these mountains back here. Hold on, I don't know if you can see them, but look at how beautiful that is. Those are the Red Rock Mountains. Just absolutely stunningly beautiful. And they're red because they have iron in them. And that iron rusts when it rains and stuff. Yes, absolutely beautiful. And cops are 5150. I've done the Cairo thing too. The problem is the disc bulge is so big that unfortunately the chiropractor treatments have exacerbated the bulge. So it's still too inflamed to really get an effective treatment, because you literally have to push that bulge back in to the disc separation. And so I'm doing everything I can, guys. I mean, glucosamine, glutamine, tons of vitamin D, quercetin. I mean, everything you can think of, I'm doing it, man. All right, so let's get into the next one. With a civil writ of habeas corpus, we've got to show that the detention violates constitutional or statutory rights. Now, the next one is going to be writs of quo warranto. And in California, that's California Code of Civil Procedure, Section 803. The purpose is to challenge a person's right to hold public office. Now, assuming that Arizona, and hopefully Lane's significant other is listening, or Reluctant Prophet is listening, this could potentially, and I am using turmeric, Dr. Donna, absolutely, 1,000,000% in my food, as well as taking the pills every day. And that's why I don't want to take pharmaceuticals, because pharmaceuticals tend to counteract or cause extreme side effects because pharmaceuticals are basically a synthesized version of a natural cure. And we know that Big Pharma, they get a patent on it because they can't sell natural cures. For them, it's all about profits. And whenever it's about profits, there's no profit in a cure. There's only profit in a treatment. Remember that. So anyways, we'll get that into another discussion on that. Hopefully Kennedy will take some steps to eliminate this cabal of the anti-human, humanist globalists who treat human beings like cattle and try to force our children to put aluminum and all these weird heavy metals inside their bodies before they're even 3 years old. Give me a bunch of ones if you agree. Now, let's see here. A writ of quo warranto, I believe possibly might apply in Lane Meyer's case. Now, assuming Arizona has a similar statutory or common law process, and I would presume they do. Now, the purpose is to challenge a person's right to hold public office or exercise a public franchise. So an example would be contesting someone's unlawful claim to a public office. Well, the issue is going to be, was it unlawful? We know that the judges in Arizona refuse to look at evidence of voter fraud, pretty much, and say there's no evidence of widespread voter fraud, but they won't allow the evidence in, so how could you prove it? So if you had evidence that a judge was unlawfully put into power by, say, drug cartels, anything like that, you could challenge. Potentially, you could also challenge it based upon their refusal to exercise good behavior, that they're not enforcing the laws based upon what the law says. So you could try it. Typically, upper court judges and lower court judges give each other great wide deference, so it'd be very difficult. But now, with respect to a city councilman or one of these people who are harassing reluctant profit, I think they might have a better shot. Because again, judges, for the most part, are elected officials, and so they may be thinking they're doing you a solid, perhaps, by getting rid of this corrupt government official, and that could potentially buttress and strengthen their power so they can continue to hold office as a judge. You guys following me so far? All right, you're right, Dr. Donna. All right, good morning, Brent. Good seeing you. All right, so now typically the problem with a writ of quo warranto is it's going to also require Attorney General approval in most cases and proof of usurpation. So it's a very, very difficult burden to meet. And again, this is a civil case. This is civil. All right. And then again, so like, for example, let's say that the local community is refusing to enforce the construction laws, and they constantly are trying to wake up reluctant profit, and we know they want to buy his house dirt cheap in this brand new, where he had all of his privacy, and now they're building stuff at like 4 a.m, causing noise, putting dust and trash on his property, and the local government officials are all getting kickbacks, perhaps from these contractors from New York City, New York. Got to get that paste pecani sauce, right? And so as a result of that, they may not be, in fact, not only not enforcing the laws, but instead harassing someone like Lane Profit indirectly by not enforcing permits. So in a case like that, he might be able to seek a writ of quo warranto. So hopefully you guys understand, against the mayor or against the building inspector, right? The people who are responsible for enforcing code regulations. Get a rope. That's right. What's the matter, you? All right. Now, the next civil writ that we'll talk about is a writ of supersedeas. And again, these are civil. So a writ of supersedeas will stay enforcement of a lower court judgment or order pending appeal. That would pause your eviction, right, if you were getting evicted from your property, until such time as your certiorari might be ruled upon. But you have to show irreparable harm and a likelihood of success on appeal. So again, if you have a bought and paid for judge who's been placed into power with drug cartel money, for example, good luck winning that. And that's why I harp on the fact that we need to worry about our judges even more than our politicians, because judges are supposed to have less power than politicians, but we've seen these Obama judges trying to order known gang members to be flown back to the United States from El Salvador. Anything they can do to increase the population of illegal aliens so they can turn the country blue using the census. And that was the whole point of flooding the country with 20 million illegal aliens. Because, let's face it, the left can't sell their policies to normal Americans. We don't buy into the whole concept that boys are girls. Most parents don't think tampon machines should be in the boys' room. Most parents don't think that grown men should be able to play sports with females. That's why they have female sports. And most people don't believe that men can get pregnant. This is less than 0.25% of the population. But with Obama and far left people like Schumer, they were able to push this bullshit narrative and fund non-governmental organizations and CNN and government-run news to push this bullshit narrative, and they really force it on our children. So that's a problem as well. So let me see here. Now let's get into criminal writs. Almost done here. Wow, guys, I can't believe I've been able to walk this long. It's because of you guys that I do this. I mean, I wouldn't be out here walking around like this if I didn't have you guys. So, well, I get what you're saying, that each branch should be equal, but actually the executive branch and the judicial branch, if you look at the history, we're actually supposed to have less power. The legislative branch was supposed to always be the gatekeeper, because remember, our country, our founders were terrified of another king. They were terrified of centralized power. And so any political party that seeks centralized power, aka the left, right? They want total centralized control over every aspect of your life. Those people have pushed a false narrative that everything's supposed to be equal. Now, I do agree, co-equal in that they can both regulate each other, but ultimately it was we, the people, directly through our legislatures, that we're supposed to hold the power. All right, give me a bunch of ones if you agree with that. Now, a writ of habeas, in other words, a court doesn't have the right to overturn statutes or misinterpret them. And that's why Thomas Aquinas said we should only put judges into power who know the law and mean to keep it well. And that's why I always say, know the law and mean to keep it well. But when the law goes against their political agenda, like they don't think people should be able to have a firearm to defend themselves, because most of the left think that we should be like Canada, give me a bunch of ones if you agree, they'll come up with some crazy decision saying that only the National Guard should be able to have firearms, which you know is bullshit based upon the history of this country. So that started with Justice Ginsburg, and that's a whole other story we'll talk about. Dangerous and unusual was a time, place, and manner restriction. It never had anything to do with the type of weapon. It had to do with when, where, and how you displayed or used the weapon. But Marxist judges don't care. So let's get back into it. Let's get into criminal. Well, probably the most important criminal writ is the writ of habeas corpus. And this is going to be where we sort of delve into what's going on with Lane Myers. So, writ of habeas corpus. Writ of habeas corpus. In California, that would be Penal Code Section 1473 et sec, right? So, in other words, it's going to be interpreted by statutes, other statutes, as well as case law, to give you a better understanding of what that means. But it challenges the legality of a person's detention or imprisonment. Examples would be seeking release or new trial due to ineffective counsel, new evidence, or constitutional violations. And obviously, Myers probably has several different routes that he could explore. If he's found additional evidence that, for example, people who don't like him are the ones who are making the phone calls to this, what's her name, Walker? What's her name? I forgot. Shannon Walker, I think. Or something like that. But obviously the strongest one is the constitutional argument. And then, of course, he also has other issues, like the judge promised him that he would have access to the law library. And of course, we know now that that jail hasn't had a law library in over 2 years, right? At least that's my understanding. So obviously that was issued in error. That detention and confinement, I would argue, was issued in error. Give me a bunch of ones if you agree, just based on that alone. So, in other words, I guess they've given him access for like a half hour or an hour a day to get on the internet, which is a poor internet connection from what I understand. And also he doesn't have privacy, because they can look at what he's looking at, which means potentially, like they did with the Eddie Gallagher case, the prosecution could literally be undermining his defenses and denying him the ability to prepare his case. And so that's another issue that we'll talk about later. But I feel that Lane is being very, very poorly mistreated in this case. I don't think that anyone demonstrated a reasonable likelihood of success at trial in order to get these detentions. Remember, he hasn't been convicted of a crime. He's simply being held because a judge and the prosecutors, who don't like him, obviously, and apparently are friends with the husband, who's also a prosecutor, one of the victims, this is wild stuff, guys, have decided that he needs to be confined because he's really dangerous, right? Even though he's never hurt anybody, But anyways, and we don't know who made all those phone calls. We know that Lane's got a lot of enemies. So it could have been somebody like Double Douche, or it could have been anyone, right? Making these calls to try and make Lane look like he's dangerous. So guilty by association at the very least. So basically, the key test is, well, an example would be seeking release or a new trial due to ineffective counsel, new evidence, or constitutional violations. In this case, Lane could argue that his lawyer was ineffective. However, I would not argue that at this point, because he's lucky that he's got a lawyer. And the more you argue that you have an ineffective lawyer, think about it. What lawyer is going to want to help you? And in this case, it's not really like he can do a whole lot. It's not like he can really do a whole lot when he's locked up and when he's being denied access to a law library. So he's been stymied. And many people are arguing that was the prosecutor's whole goal, was to stymie him, because every time he does have access to legal materials, he keeps winning in court. Despite his bombastic behavior, what many judges would consider to be outrageous behavior, I would be disbarred if I acted the way that he acts in court. He keeps winning. And so when I initially saw him, that still is my biggest problem with Lane. If he could keep it cool and be more civil, the people that want to lock him up would lose about 80% of their firepower, because all they're trying to do is make him look like a crazy person. And most juries, let's face it, if you agree with me, do you think most juries really rule on what the law is? Or do you think they rule on personalities? I would say I've won 90% of my cases based upon the fact that people like and trust me. And that's real. Think about it. All right, so let's see here. All right. Hopefully you guys are learning. You guys learning stuff? You guys learning stuff? Give me a bunch of ones if you're learning stuff. Because I'm not here to, look, I've never made money off my YouTube channel. When you guys give me donations or buy memberships, I typically spread the wealth around, but I don't do it because of an Obama mandate. I do it because I want to help people. I get to decide who gets the money, not the Democrat Party. So I've donated an enormous amount of whatever I get to This Is a Public Service, to Reluctant Prophet, and to Lane Meyer's charity, because I get to decide, not some Marxist politician, who deserves to get my help. And that's the problem that I have with most politicians, is they'll steal your money and give it to people who help them get elected, or their corporations, right? So we don't believe in that at Team MPE, do we? What's going on, Wesley? Good seeing you. All right. It says here, Clueless Beekeeping says, I'm way behind the real-time exercise. Brent says, is Lane required to file a writ on his own behalf, or should the public defender? Well, typically, extraordinary remedies like writs aren't required. So Lane is really going to have to push his public defender, or in this case, I think he's got a private attorney that's paid by the government. So for example, if I do work for the California Appellate Project to get people out of prison, I think I get like 50 or $100 an hour, which is, I bill out at $500 an hour, guys, minimum, just because my overhead is so high. I don't have a choice. All the regulations that the government has placed upon my firm, including employment law and all this other stuff, there's no way that you could support a firm with anything less. So again, it's even hard to find a lawyer. So in that case, I don't think that his lawyer would be required to file a writ. However, if I was able to pro hoc in and donate my services pro bono, which I would do if I can get in and I can work a deal with Lane and his counsel. Remember, lawyers got huge egos. And I'm not an Arizona attorney, so I would have to spend a minimum of 40 to 100 hours to brush up on their statutory, legislative, and common law scheme. Minimum, which I would gladly do. And that's another reason why I'm here at the park walking, to try and get my sciatic nerve pain under control. Because I don't think a lot of you guys understand this, but I'm more concerned about Lane's significant other than I am about Lane, because I know that when you strip a family apart, it destroys the spiritual energy that our Creator put within all of us, and it leads to depression and a lot of other problems. Give me a bunch of ones if you agree. And that's what I'm doing it for, is to try to get that family back together again, because they obviously care about each other. So that would be my goal here, to try and restore the family bond. And if they got dogs or pets, that's what I would be looking to do. So now, if I could, assuming arguendo that I'm able to do all this, and I've got my daughter researching the pro hoc vice scheme in Arizona. If there's a way that I can get admitted and by the way, I still would have to get the court to admit me. And I'm sure that if the court or the prosecutor showed the court my videos supporting Lane, supporting natural law, supporting the concept that your rights don't come from the government, if we have a Marxist judge or a far left judge, there's a very low probability, in my opinion, that I would get accepted to become part of Lane's legal team. And that's another problem. And unfortunately also, I'm not able to give legal advice about an Arizona case if I'm not an Arizona attorney. And you know I've got a target on me because I accept unpopular causes. People like Lane, people like Chili DeCastro. And so typically the deep state, the one world government types don't like lawyers like me who don't get completely brainwashed in the Marxist run education system. Give me a bunch of ones if you agree. Now, the next thing that somebody like Lane could do, again, if he was in California, would be a writ of prohibition. And this is the criminal part, all right, not the civil. So the purpose of a writ of prohibition in California would be preventing a lower court from proceeding in a criminal case where it lacks jurisdiction or is about to commit a serious legal error. And I would argue, if Lane was in California, that the judge said on the record that you would not be denied access to the law library. Well, the spirit of his order meant a physical law library. And obviously, anyone who knows anything about law would know that 45 minutes to an hour on a crummy internet connection at a prison, where you might be being monitored by the prison as well as the prosecutor, denies you the right to prepare an adequate defense. So that would be my argument. I would argue that the court is prohibited from imprisoning me, or at least seek a modification in order to be bused to a real law library, because that would be complying with the spirit of the judge's original order. Give me a bunch of ones if you agree. Now, that would basically stop the trial court from hearing a case barred by double jeopardy. That would be another example. Something like that, to prohibit the court from, like, let's say you've already been convicted and served your time on one sentence and the court's trying to try it again. Like the Dukes of Hazzard style crap that you hear about in the Deep South back in like the 60s, right? Now, the key test is you have to demonstrate an excess of jurisdiction or abuse of discretion. And those are two standards that are almost impossible to meet. So good luck, but I've done it before. And again, if you attack the judge and call him names and stuff like that, it's very difficult to get these things reversed. You've always got to be able to give them an out, and that's where knowing how to have basic civility. I recommend that you people read books like How to Master the Art of Selling by Tom Hopkins. I recommend that you learn a little bit about Norman Vincent Peale, What the Mind Can Conceive and Believe the Mind Can Achieve, and that will help you do better in court. But especially with police interactions, like you auditor types who want to yell and scream and cuss at these cops, it makes for good YouTube videos, but when it comes time to get out of jail, people look at you like you're a crazy person. Hey, what's going on, BZ? So now the next one is writ of mandate. A writ of mandate compels a lower court or court official to act in a criminal case, like to enforce the defendant's rights. So in this case, arguably, if I had Lane's case in California, I would say, Your Honor, your order, or actually, well, even if it wasn't part of the order, your statements on the record in my court transcript are very clear that I would have access to a law library. The issue is, Your Honor, assuming arguendo, because I know that you would never do anything below board, assuming arguendo that you didn't know there is no law library at the jail, I think that I need to seek a writ of mandate to a higher court, typically a 3-judge panel, that you're mandated to allow me access to a law library, number one, and number two, a half hour on the internet does not constitute the law library. All right, so what do you guys think? You think that's a good argument? That's what I would argue. And so that would direct the lower court official, in this case the judge, to enforce his right to have access to the law library. And this is aside from mandating that he be released because there was not substantial legal or factual evidence that Lane Myers was responsible for the phone calls to Shannon Walker by other third parties. There just wasn't enough evidence to show a reasonable likelihood of success on the merits and that he shouldn't be confined, number one. And number two, Lane doesn't have a record of violence. And obviously, if he wanted to be violent, he wouldn't have been making phone calls to try and hold public officials like Shannon Walker accountable. He would be committing violence against her. Give me a bunch of ones if you agree. That's what I would argue. So what you would want to, like another example would be ordering a court to hold a hearing on a suppressed evidence motion where they refuse to do it. Or, but typically, again, you've got to show a clear duty and no adequate alternative remedy. And we'll hear, obviously, what the court could counter with. In this case, he's basically arguing against the judge, unfortunately. The judge can counter with, well, he's already got his own attorney. He's not pro per, and therefore he doesn't need access to the law library, even though I said he could have access to it. And of course, we all know that that would be a sort of a feckless kind of an argument, because I think everybody knows that Lane was trying to file a motion to have his attorney fired. And so the response by the court system and the prosecutor's office was to make sure he got confined, almost like a chess match, to make sure that he would be stuck with a government-appointed lawyer. And so there's just a lot of issues that come up here that are very, very disconcerting to me that I think need to be addressed. Now, most of this stuff, unfortunately, probably would have to be addressed on a political level, such as recalls, signature drives. And if you guys don't get active and really raise hell, like Black Lives Matter and all the George Soros organizations that bus paid protesters in to make it look like they have a majority, I don't think you're going to have much of a chance on a political level. Now, the next issue you could address would be a writ of coram nobis. Now, a coram nobis corrects fundamental errors of fact in a criminal case after judgment not apparent in the record. So if Lane was not able to properly, because of perhaps ineffective assistance of counsel, was not able to address issues that were suppressed at his hearing, he could try to do a coram nobis, and we could get vacate the conviction based on newly discovered evidence, for example. So typically a writ of coram nobis is like a motion for a new trial in California based upon newly discovered evidence. So in this case, if Lane was able to discover that these phone calls or that Shannon Walker had lied and produce that evidence, that could potentially enable him, if it was California, to get a new trial. And in this case, I'm not reasonably sure that a hearing for confinement based upon a non-criminal trial. Remember, this trial was just to see whether or not he might have a chance at winning if the case actually goes to trial. So this was more like a restraining order type of a hearing. So I don't even know if a coram nobis would be something you could use in Arizona. I'm not an Arizona lawyer, again. I'm not practicing law in Arizona, but I've got over 20 years experience, and I externed for the California Court of Appeal. I think I'm the only graduate of the law study program to have done that. And again, guys, when I first saw Lane, I thought, hey, this guy's a crazy person. What is he doing audio recording in court? You can't do that. But I never made a hard and fast statement that he was wrong, because I learned a long time ago that you don't insult and call people wrong like this MERB guy or this direct douche guy. You try and learn and understand what's going on before you make stupid comments and start calling people names. But once you have the evidence that they're idiots, then feel free to call them idiots. But in this case, I didn't see that with Lane. What I saw is a guy who probably has some post-traumatic stress issues, probably from being confined. I know a lot of people, my friends who are Marines, combat vets who have it, and he does appear to have some of those symptoms. And simply, probably a misunderstood guy. He's loud, he comes off as obnoxious and rude, but ultimately I found that the guy is legally he's a gifted guy. I think he probably has an incredibly high IQ. He almost kind of reminded me of some buddies of mine who have Tourette's and Asperger's, and most people like that are socially incapable of having relationships, and they're misunderstood, and they typically do get falsely convicted and falsely accused of things because they're not in what's called the norm. Give me a bunch of ones if you guys know anybody like that. So hey, what's going on, Rooster? Good seeing you. Brent Shimko. I'm trying to escape all these gardeners with their machines. Trying to get back to home base here. But anyways, guys, so what I see is a grave injustice being committed against Lane, and I feel that if he does go to a jury trial with his personality, it's going to be very difficult for him to win. And so I think that the court recognizes that, and I think that the prosecutor recognizes that. And so, and again, this is another reason why I support jury nullification. I mean, I would just mistry a case like this forever until the prosecutor finally gave up. But at the end of the day, based on the evidence, based upon the law. So jury nullification simply means that, like Thomas Jefferson, like John Jay, our founding fathers believed that the jury should have the right to decide both the facts and the law. But the modern judicial system makes you swear during voir dire that you'll only decide the facts. And that way they can get you for perjury if you base your decision on the law. And so when I get called to a jury, because I've written articles about jury nullification, and people know that I support it because our founding fathers supported it, and I believe in the Constitution and the Bill of Rights over a statutory scheme, that I'm automatically disqualified from serving on a jury. And you would be too if you admitted that you supported jury nullification, or if you ever spoke about it and they found out online, you could be thrown in prison for perjury. So that's how they get you. It's not that jury nullification is not allowed. It's that they have a scheme, a process to make sure that anybody who supports the concept of jury nullification is DQ'd, or if they're not DQ'd, that they can go to jail if they do engage in deciding both the facts and the law. And if I feel that the law is being applied in a way that unfairly targets somebody like Ehline Myers, I'm the kind of guy who would absolutely nullify the case. Now, that doesn't mean the case would be over. What that means is that the case would have to be retried, because it would be what's called the hung jury. Give me a bunch of ones if you guys understand. By the way, do you have any questions? I've been talking quite a bit, Brent and Zoom, Smokey. So I just want to know if I've been clear enough for everybody this morning, because I want to make sure you guys understand what's going on. All right, so, man, I got the sun right in my face. This is exactly where you don't want your enemy to be, in front of you in a case like this. All right, cool, right on, Wassa. So, in any event, I'm concerned that, you know, and look, I have a different take than a lot of you guys. I'm a pretty level-headed, well-grounded guy. And I got to tell you, you know, pretty much 99% of the so-called conspiracy theories that were called conspiracy theories by government-run news like CNN, PMSNBC, even Fox News, what they call conspiracy theories have all come true. Pretty much all of them. And I've heard a lot of people say that Lane is a political prisoner and he's being unfairly targeted. I haven't seen all the evidence, but I have a hunch, a sneaking suspicion, that he is somewhat of a political prisoner here. And I think that from what I've heard, that Arizona does seem to be a bit of a good old boy network. And I don't even know that I would be admitted to be pro hoc vice, again, because of my unpopular views. I think that these guys have it in for them, based on my opinion as a non-attorney, but just as a regular person like you. And that's why I've been doing these shows. And again, I don't make money off YouTube videos, and most of the time I donate whatever you guys give me in super chats, or, I just say, hey, give me $1.99. Don't even give me $50 or $100. Just if every one of you guys donated $1.99 to Team MPE, in time that could add up, and that could build up my war chest so I could get merch, so I could, go live more and do less freelance work as a lawyer and more work online supporting things that I believe in. Especially as I age and I see the younger crowd just not having anyone out there who knows what they're doing, flailing in the wind. It really makes me want to educate you guys and teach you about our amazing republic, natural law, homeschooling, homesteading, getting off of the government-run news, and start taking back your rights as an American. Stop allowing these leftists from Harvard, UCLA, USC, brainwashed to hate their country, get appointed to the bench. What do you think is going to happen to your rights when you let people who have been taught since they've been in kindergarten to hate their country, to think that boys are girls and girls are boys? What do you think is going to happen to your rights? All right. So let's see here. Now, guys, another thing, I do see some people are arguing or something, or trash talking each other in my comments. And so one of the things that I love about my channel is that I've got Democrats, I've got Republicans, libertarians like me, all in here because we support natural law and the concept of individual rights and freedom. So please, guys, like Reagan said, speak no ill of a fellow Republican. Try and get along with each other and agree on the things that are most important. Our children, homeschooling, homesteading, growing your own food, forming parallel systems, getting off of big pharma and all the nonsense, and looking after your unalienable rights. Because the whole idea of libertarian ideals and anti-federalism, which I am an anti-federalist, is that we agree on the most important things and we leave everything else at the door. If we've got to go to war and I'm with a battalion of Marines, I don't care what your views are on some things, but I do care that you support the flag, you support God and country, and that you're going to make sure that you bring my body home, dead or alive, to my mother. Give me a bunch of ones if you agree. That's the Team MPE philosophy. So try to get along as best as you can. Again, thank you guys for supporting my channel. Thank you for the super chats, for the memberships. It really means a lot to me, you guys, helping me out. And especially my daughter, because I'm teaching her how to do a YouTube channel. I homeschool my kids, and I want to make sure that they learn how to be entrepreneurs. And so I'm teaching her how to do the video shorts and all that. So when she sees that there's money coming in from doing this, hopefully she won't get a job as a barista at Starbucks and change her gender overnight, and instead will understand how beautiful it is to form relationships with other people and build parallel systems outside of government-run nonsense and the fiat currency system that we have. So, hoorah, Easy Watchdog. So, I will, again, guys, make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. And with that being said, hopefully I'll be able to go live tonight, but surely I'll go live this weekend. And maybe I can do something with John Felix, like a fundraiser for Lane. Maybe we can get Reluctant Prophet, and this is a public service. Maybe we can all pool our resources together to try and help out Lane and his, for lack of a better word, his wife. Again, that is my biggest concern, is that you know, having that family separated is a terrible, terrible thing to me. And I'm really, really hoping that we can have some common sense and the cooler heads will prevail in this case, and that we can get Lane out of jail and get these charges eliminated. So good seeing you, cops for 5150, Brent Shimko, Age Go, all you guys, Speak Life Garden, Simba B, let me see who else. Bunch of people, Rooster. Anyways, guys, it was really, really an honor to be able to spend this time with you. So I'll talk to you guys soon. Semper Fi, do or die.